Court of Appeals of Tennessee is now in session.
Good morning. Before we call the case, just a quick comment. We don't anticipate any technology-related problems, but if we should have any, everybody just take a deep breath and pause, and we'll work through it. Call the case, please.
Relyant Global, LLC versus Royden, Fernandez, et al.
We'll hear from the appellate.
Hey, please the court. I'm Jim Price, and I'm representing Relyant Global here today. Just as a housekeeping matter, I've already advised the clerk that I would like to reserve 2 minutes for rebuttal.
Yes.
Briefly, this case involves the breach of what I will shorthandedly refer to as a non-compete agreement. Relyant Global filed suit against the defendants for breach of that non-compete agreement. The defendants filed a motion to dismiss. Prior to ruling on the motion to dismiss, the trial court did not allow the parties to engage in any discovery. And after a non-evidentiary hearing, the trial court held in its order that the court did have subject matter jurisdiction over the dispute of the parties, that the court did have personal jurisdiction over the parties, but nonetheless, the court dismissed the claims of Relyant based upon application of the doctrine of forum nonconvenience. After that hearing, Relyant timely appealed, and on appeal, Relyant raises 3 issues. One, that the trial court abused its discretion by completely disregarding the parties' waiver or the defendant's waiver of the defense of forum nonconvenience. Secondly, that the trial court abused its discretion by disregarding the mandatory forum selection clause that the parties agreed to in the non-compete agreement. And 3, that even if the court did in fact reach a point where it could apply the doctrine of forum nonconvenience, that the court improperly applied that doctrine at the point in litigation at which we were at that time. With regard to the first issue, which I believe is the dispositive issue in this matter, paragraph 9 of the parties' non-compete agreement sets out the mandatory forum selection clause, and the court reflects that in its entirety in paragraph 6 of its order. Then in paragraph 7 of the court's order, the court finds that it is assumed that that forum selection clause is valid for purposes of its order. Yet the court completely ignores the defendant's express waiver of the doctrine of the defense of forum nonconvenience, which in this particular instance states each party consents to personal jurisdiction thereto and waives any defenses based upon personal jurisdiction, venue, and inconvenient forum. I think the parties agree that whether the defendant's express waiver of the defense of inconvenient forum is a pure question of law, and it is in fact, we think, a question of first impression in Tennessee. What the defendants asked this court to do is to do as the trial court did and ignore the express waiver that the defendants entered into in the non-compete agreement. For this court to do that is to take away the party's right to negotiate the terms of an agreement that they see fit. And in fact, that would be very unfriendly to Tennessee businesses as those businesses seek to do businesses with non-Tennessee businesses. As set out in paragraph 18 of our brief, we believe that it is well settled law that the parties to a contractor free to contract for the terms that they see fit to include in the contract unless those terms violate public policy. There was no, and there is no public policy that the defendants point to that has been violated, nor did the trial court find any public policy that was violated.
Mr. Price, let me ask you this. In the Dyersburg case, that sets forth the factors that courts are to look at when determining whether to uphold the validity of a forum selection clause. And one of those factors is, of course, the convenience of the forum. So is it your position that when parties choose to specifically waive the defense of forum nonconvenience, that factor in the Dyersburg case, when looking at the overall forum selection clause, just simply the court doesn't look at that factor, or it's already been determined because the parties agreed on it? How does the court deal with that factor?
And so we believe that by agreeing to an express waiver, that the defendants completely waive that defense of inconvenient forum. Therefore, the court is not to apply the Dyersburg factors, or as the defendants argue, that the factors in the package express case. We believe
No,
that
we don't even get to Dyersburg. We just say you've waived it, and that's it.
you've waived it. You've agreed that that is something that you want to include in the contract. And unless that waiver is against public policy, which we don't believe there is any violation of public policy by entering into that express waiver, there is no analysis under the doctrine of forum inconvenience or the Dyersburg factors as you've set out here.
I just made that term up.
Okay. And so we believe that's why stated earlier, I believe that this express waiver is dispositive of this issue in its entirety. And we don't get to the other issues, which I will briefly address in case the court doesn't agree with me. But the only argument the defendants make with regard to the express waiver is they want this court to hold that application of the doctrine of forum inconvenience as a tool that a court can raise sua sponte, similar to a court dismissing a case for failing to prosecute or for failing to comply with rules of civil procedure. And those are entirely different situations from a court choosing the jurisdiction of a dispute for the parties sua sponte. What the defendants point you to are some federal cases which are not directly on point, but I do want to take a minute to point out that the cases that the defendants cite, the federal cases they cite to Wong and Branch versus Mays, in fact, are cases where the federal courts have found that the forum selection clauses in those cases were in fact enforceable. And then the court goes through the doctrine analysis of forum nonconvenience to ensure that that forum selection clause is enforced. And so that actually supports, we believe, what the Supreme Court in Dyersburg held, that there's a different standard when you have a forum selection clause that is in a contract as opposed to a situation which is the situation that the package express case relied on from the Zurich case, which is a car wreck case where there was no forum selection clause, to hold that there's a more traditional analysis to be applied in that situation. Ultimately, we believe the trial court abused its discretion by ignoring the express waiver, and we believe that the trial court's dismissal should be reversed. Next, with regard to the second issue, we believe that the court abused its discretion by applying the incorrect legal standard when it assumed that the party's forum selection clause was in fact enforceable, but refused to enforce it. In Tennessee, whether a forum selection clause is enforceable, as the court has already pointed out, is set out in the Dyersburg case. And as the court pointed out, there are factors that the court is to look at under the Dyersburg analysis. And I would point out that one of the factors is whether the other state would be substantially, which is a different standard than under traditional forum nonconvenience analysis. Would the other state be substantially less convenient for trial of the action than this state? But I think the most important factor, which the court made no effort to apply, is whether the agreement was obtained by misrepresentation, duress, abuse of economic power, or other unconscionable means. There's no evidence that any of that was present in this case. The defendants argue that it was acceptable for the trial court to ignore the Dyersburg factors, and that a separate analysis from that analysis was appropriate. But forum nonconvenience doesn't allow the court to ignore a valid forum selection clause, which this court in its order found was the case. We think the Dyersburg opinion of the Supreme Court is on point, and would point out that the Package Express case that the defendants rely on is actually a decision of the Court of Appeals, and is clearly distinguishable from the present case because in Package Express there was no express waiver in the forum selection clause as there is here. And so we don't
have any Tennessee cases that have addressed the validity of a forum selection clause, correct?
We do have cases addressing the
not a
validity.
forum selection, my bad, a waiver of the defense of forum nonconvenience.
I think Mr. Russell and I both agree that that's the case, that there are no Tennessee cases. And so this is a question of, or a case of first impression for this court to decide.
Counsel, were there any cases where neither side raised that issue, forum nonconvenience, but the trial court did it on its own? Did you come across any of those?
I don't believe that we found any Tennessee cases where that occurred, but I'm sure there were cases that we found in other jurisdictions, as we had to look outside this jurisdiction, given that we believe this is a case of first impression. But I don't recall any specific cases where that was the case. As I said, the cases that the defendants point to from the federal court actually involve cases where there were forum selection clauses, and the court found those to be enforceable. So we believe that the court would be doing a tremendous disservice to Relyant if it does not enforce the express waiver or the mandatory forum selection clause. And we believe, as a case of first impression in Tennessee, that it would be very unfriendly to Tennessee businesses to so hold.
Thank you, counsel. You have your time for rebuttal. We're here from the appellee.
Hey, police and court, can you hear me?
Yes.
Adam Russell here on behalf of the appellees Ohio MEC Remediation LLC. I'm just going to refer to them as Defendant LLC, and Royden Fernandez. I'll briefly touch on the standard of review, and then I'll address the Chancellor's ruling with respect to Defendant LLC, and conclude by addressing the Chancellor's ruling with respect to Defendant Fernandez. Briefly on the standard of review, as your honors know, in this case, there's no transcript or statement of the evidence that's been submitted. And so there is a presumption that the parties presented sufficient evidence to support the trial court's ruling. And as the court knows, in this instance, in the application of a forum non-convened, the review is whether the trial court abused its discretion. In this case, obviously, we submit that the trial court did not abuse its discretion. First, with respect to defendant LLC, we would strongly disagree that the waiver is dispositive as to the defendant LLC. As we briefed, the defendant LLC, there's no question, is a distinct separate legal entity formed in the territory of Guam, that the defendant LLC has 3 members, one of which is the defendant Fernandez. There's no question that the defendant LLC is not a party to the non-compete. So when the non-compete speaks to the party's waiver, that cannot apply to the defendant LLC, as it is not a signatory to the agreement. Because it's not a signatory to the agreement, there can be no argument that it is either bound by the forum selection clause or that it waived its challenge based upon an inconvenient forum. Blount County, Tennessee does not have personal jurisdiction over the defendant LLC under the long-arm statute. As plaintiff's complaint alleges, the defendant LLC transacts business in Guam. Any tortious acts or omissions occurred in Guam. Defendant LLC doesn't own property in Tennessee, and it did not enter into contract for services in Tennessee. Respectfully, we submit that the plaintiff's attempt to assert the alter ego theory to subject the defendant LLC to the jurisdiction of Blount County is simply misplaced. The alter ego theory is used most commonly to pierce the corporate veil to hold those individual shareholders or members individually liable for the debt and obligations of the entity. By contrast, in what the plaintiff appellant is attempting to do is to reverse pierce, or essentially hold the defendant LLC responsible for the obligations of its individual member. And there, it's cited on page 16 of our brief. There are numerous authorities starting back in 2000, going all the way to 2004, and then quoted and adopted in the Sixth Circuit in 2020 that stand for the proposition that there is no authority under Tennessee law for reverse piercing the corporate veil outside of the parent subsidiary context. So we would submit that the chancellor was correct in finding that the defendant LLC, well, he didn't say that they were bound by the non-compete because he wasn't a signatory to it. So we would submit that the chancellor was correct in finding the LLC to be a separate, distinct legal entity, and by dismissing the LLC based upon the factors of under form non-convene. And whether it was waived or not was not at issue because they did not sign the agreement. So we would submit that under any circumstance, the order should be upheld with respect to the dismissal of the defendant LLC. And I think that ultimately puts us in the position of really having to figure out, well, what do we do then, right? Because we have a desire to litigate all claims in one forum, to resolve all issues in one action. And the plaintiff's action seeks to enjoin not only the individual defendant, but also the defendant LLC from violating the terms of a non-compete. Well, by that very nature, if the defendant LLC is not a party to the action, then complete relief cannot be afforded in Blount County. And I think that was where the chancellor ultimately fell. And as noted in his order, enforcing any judgment of injunction rendered by his court in Blount County in the territory of Guam, which I believe it's about 11 p.m. there, would be very difficult. There's no relief to be afforded in Blount County, in other words. What the plaintiff is seeking to do is keep the defendant individually and his company from competing, but the services to be rendered are only to be rendered in the territory of Guam. So what that would necessarily entail, and I think the chancellor was correct in ultimately dismissing everything, was if he were to enjoin the defendant individually from competing in Guam, the plaintiff would necessarily have to enroll that in the territory of Guam, which would then take additional judicial resources to enforce in the territory of Guam. And then how can the chancellor oversee that if there's some issue with whether the enforcement is being done properly by a Guam court? I'm not familiar with
Mr.
Guam
Russell,
court.
I think that's an interesting argument and a good one to make, but I think it sort of puts the cart before the horse, because I think before we decide what the effect of having potentially the LLC in one jurisdiction and the individual defendant in another, we have to address the second issue, which to me is the primary issue, which to me the court never really addressed. And that was the validity of the waiver of forum nonconvenience. I mean, let's start with that, because the issues with respect to the LLC to me are almost for another day. If we get to that point where you might have one person in one jurisdiction and one in another. What do we do with the fact that the court really did not address at all the validity of that waiver?
Well, I will say, frankly, I don't think it really was argued. I don't know that the judge really, the chancellor really brought that up. I don't know why, but I think what we would do was we would have to, I think we have to determine whether a court can say Blount County is not a convenient forum for this action, despite there being a waiver of that defense. Because I mean, I think you talk about public policy. I understand their argument on the business side, but if we have a situation where you can write into every agreement that you are waiving forum nonconvenience, then why do we not end up having every case being decided in state courts involving parties and actions and controversies from all over the country? And if the judge can, I believe, and I mean, that's kind of what my argument is that the chancellor, I believe, ought to have the ability to evaluate, especially in an instance where one party hasn't waived it. I mean, there is a distinction in this case that probably wouldn't apply in a lot of cases. When one party hasn't waived it and therefore can at least bring the argument, the court ought to be able to engage in the private factors analysis and the public factors analysis, which it did do, to determine whether a other form is more appropriate. And I believe
we're going to take away the ability of businesses and individuals really to decide what they want to put in their contracts.
I think I would say that I would allow a chancellor to blue line it like he would any other provision of a non-compete agreement. If in a non-compete context, it's very common for judges to revise, whether it be duration, right? I've seen chancellors take it from 2 years down to 1 year, or whether it be territory. In this instance, I think it's similar to where the chancellor could say, I understand this is what you agreed to, but under the facts, there's another form available. This is not a convenient form for Blount County to adjudicate this matter. The relief that you're seeking is appropriate and available in another form. And if that is not the case, then I think you're correct. The parties can agree and the judge would follow it. But in the instance where those circumstances are still present, i.e. another alternate forum, the relief to be afforded a defendant who hasn't signed a waiver. I think there should still be some discretion for the chancellor to look at his docket and say, this is not a case that I want to spend the next 2 years of the resources of this county adjudicating. With respect to defendant Fernandez, the court did find that the validity of the forum selection clause was a separate analysis from whether the factors of the, I guess it's the Zurich and then the Bridgestone progeny. He went through those factors in depth and ultimately concluded, like I said at the beginning, that it would be very difficult to enforce any injunctive relief that the majority of the parties, including, and there was a declaration from defendant Fernandez, which the court relied upon, which outlined where the work was to be performed, where the contract allegedly was signed, and where the primary contact for the plaintiff was located, all in Guam. The court did look through those things, and I'll briefly touch on the discovery issue. There was a case, I don't have it right in front of me, but I cited the case that I don't have a case, I'm sorry, but essentially it was the ability to allow a party to conduct discovery prior to determining whether the forum is appropriate kind of destroys the whole purpose of the forum non-convene analysis. In other words, if you're going to engage in discovery, you've already kind of subjected yourself to that forum, and therefore the resources of that forum are still being used. So I would submit that the chancellor was correct in declining to conduct any discovery or allow the defendants to, the plaintiffs to conduct any discovery. The Supreme Court in Zurich, Inman did say that courts of general jurisdiction do have the inherent power to apply the doctrine of forum non-convene. I think the question is, how far does that inherent power go? And can the trial courts blue line a waiver of that defense under very narrow facts where one party hasn't waived that defense? And so I guess, Judge Davis, what I would say would be, I agree that parties should be able to contract as they see fit, and that courts are going to uphold contracts, and that's an important rule of law in Tennessee, and it's established. But I don't think that should be the case in all situations, because like in this instance, you now have a Blount County chancellor who has already expressed extreme concerns by way of dismissal in this thing, concerns with proceeding forward, where it looks like everything that he's going to be ruling on is only going to be enforced in a territory that is half a day away, essentially. So we would respectfully request that the court uphold the trial court's order dismissing the plaintiff's action without prejudice. Thank you.
Thank you, counsel. We'll hear from the appellant in rebuttal. Counsel, you need to unmute it.
I apologize. If the court disagrees with our analysis that the express waiver and the mandatory forum selection clause should be enforced as agreed upon by the parties, we would further point to the court that we believe that the trial court erred by applying the forum nonconvenience factors the way that they were applied, by failing to take any evidence as to the location of witnesses, what those witnesses would testify to, and the real factor as set out in Zurich versus Inman is whether there's a strong likelihood that the defendant would be done an injustice if forced to go to trial in the forum that the party selected. The court didn't make that analysis. The court simply, in its order, assumed that all of the witnesses were in Guam. That's not true and was not based upon any evidence whatsoever. It was just an assumption that the court made. We believe that was clearly erroneous, if not an abuse of discretion. Quickly, also, we did in fact raise the waiver issue in our response to the motion to dismiss on page 5. And we would again encourage the court that failing to enforce the express waiver would take away the party's freedom to contract.
Counsel, I'm going to interrupt you. Your time's about out, but just very briefly, can you address the fact that the LLC, Guam LLC, is not party to the agreement?
Yes, I can. In response to that point, Your Honor, the LLC not being a signatory to the non-compete agreement, we pled that the LLC was Mr. Fernandez's alter ego, that he created the LLC solely for the purpose of competing indirectly through the LLC with Relyant in violation of the non-competition provision, which unfortunately is misnumbered, but it immediately follows paragraph number 3, non-solicitation, and is titled non-competition in the non-compete agreement. And it says that the employee will not either directly or indirectly compete. And that's what the purpose of the LLC was created for. And we believe at the motion to dismiss stage that was sufficient to treat the LLC as bound by the non-compete, including the forum selection clause and the express waiver.
All right. Court's thanks to counsel for your oral argument today and for your briefs. We appreciate it. If you would please recess court until 1:30 this afternoon.
Court of Appeals of Tennessee is now in recess.